I'm Julian Smart. I head up the Professional Indemnity group at BLM, and I'm really going to talk about one of the things that I was asked to talk about was professional indemnity. Well, I thought, well, that's all very interesting, but let's try and make it relevant to you guys, because that's far more likely that you're going to stay awake that way and actually find it interesting. So what I'm going to do, this is just an overview of what we're going to look at. And I think we need to take it right back a bit to intermediaries. What are the duties we saw as brokers in their traditional capacity? And then just take it a bit further forward and then to examine the unique position of an MGA, some of the specific duties and obligations of MGAs, areas where there can be breaches of duty that you need to look out for. What are the likely remedies that people are going to ask for if in the event that there is a problem and, God forbid it, you are sued? Conflicts of interest, just a little bit about those and how to manage those. Some risk mitigation against claims. And finally, just a few points on professional indemnity insurance generally in the market for MGAs. So, let's go back to the basics. Now, this is something you will all be familiar with and all be comfortable with. The traditional position between a broker and an insured is what we call as principal and agent. So the insured is the principal, the broker is the agent of the insured. And in that kind of a situation, I think it's important just to take it back to these basics, because we can see how things have evolved. You've obviously got a contractual duty, and we also talk about a duty in tort, which can be imposed. So you have a duty of care in the tort of negligence. There are also fiduciary duties. Wherever you are acting as an agent for someone else, whether it's an insurer, and I'm going to just use the broad expression insurer today because it is actually just the easiest way of understanding it, or whether it's the insured, fiduciary duties exist if you are an agent. And a fiduciary it's quite an onus actually. You have a responsibility not to put yourself in a position where your fiduciary duties conflict with your own duties, or your own interests, sorry. And so, for example, you must account for any secret profits you're making. I don't know how often that occurs. I'm going to actually look at that. It does happen. You must act honestly, faithfully, and loyally, and in the best interests of the principal. So what about between the insurer and the broker? Because that's a slightly different one. Well, there is, again, traditional position, there is no contract, is there? There's no contract, and the courts are going to be reluctant to impose this duty in tort as well, okay? Except in some situations, which we can also think about, and that is generally where there is a fraudulent misrepresentation made by an agent. Now that would entitle the insurer to avoid the policy under the current law as it is, and to claim damages against the agent. Okay, so we've looked at relationship between the insured and the broker, the relationship between the insurer and the broker. What about brokers and sub-brokers? Typically producing and placing brokers. What are the relationships going on there? Well, to start with, there are obviously contractual and what we call tortious is the adjective, so just excuse the legal, but there are obviously tortious relationships as well. A placing broker owes a duty to perform the tasks delegated to him with reasonable skill and care. But the producing broker, if he doesn't do that and he makes errors, the producing broker is liable for those errors to the original client, whatever happens. So that's also something. So if you have a client in the States and the producing broker refers you to the Lloyd's market, to the placing broker, and placing broker makes a mistake, then the broker in the States is liable for the errors of that agent in the London market. Now, there may be situations where actually you've got the client in America who wants to sue the placing broker in the London market. Now, he can't do that by contract because there's no contract. His contract is with the producing broker in the States. He can't sue in contract. Can he? Is there a duty of care between the broker in the London market and the client in the States? Quick show of hands. Who thinks, and it's not a trick question, who thinks there might be a duty of care between the broker in London and the placing broker in London, and who thinks there won't be? Yeah. Well, guess what? The courts have gone both ways as well. All right. It really depends. In this case, Pangood and Barclays, that I've just mentioned. Pangood were nightclub owners, and they wanted insurance for fire for their nightclub, and they went to the London market via a producing and placing broker, and insurers put in a warranty about smoking materials being contained at the end of the day in a metal receptacle, something, quite standard. And anyway, didn't get back to the client that warranty. They didn't know about it. What happened? Of course, there was a fire. Insurers declined cover, breach of warranty, and they tried to get in the placing broker. And in that case, the court said, well, actually, the placing broker had a very limited role. It was just literally to get a quotation and communicate it accurately to the producing broker. And they said there's no duty of care between states and, well, in this case, they weren't in the States, but the nightclub owners and the placing broker. Contrast that with this case of BP and Aon. Much different case, much bigger case. But BP had gone to Aon Texas for some insurance, but they'd also gone to Aon London, and Aon London had some involvement. And it all went wrong, obviously. But the judge in that said, Aon London had taken on responsibility of making declarations to insurers under an open cover agreement and owed a duty of care to the companies intended to be insured under that agreement. They'd had a much more hands-on role. They were much more closely connected with BP, and therefore they had assumed a responsibility, a duty. Okay. So I think that is interesting, the way that the laws developed, and also the way that you weren't sure the position, and actually the courts have gone both ways as well. Okay, what about brokers who have got agency agreements as well? They've got their relationship with the client, but they've also got an agency agreement with the insurer. They've got two agency agreements going on, one with the insurer, one with the insured. Now, they have two obligations of fiduciary duty there, so you have to be really careful about managing those kind of relationships. And it can also lead to some quite unusual situations. So let's say, for example, in that relationship, the broker fails to disclose some material information. He gets it from the insured, he has it, he doesn't communicate it to the insurer. What happens there? Can the insurer take a non-disclosure point and avoid the contract? Well, the answer there is possibly not, because it has been successfully argued that the broker has the knowledge. He's the agent of the insurer, and the insurer is what we call imputed with the knowledge of the broker. So these kind of, and so they can't take a non-disclosure point. So it does lead to these rather strange situations like that. So that's just a bit of background about the various relationships that can happen, the various obligations in the marketplace, and the duties and some of the things you need to look out for. Now let's turn to MGAs specifically. Defined by the FCA as wholesale intermediaries, as you know, you act as the agent of the insurer, not the insured, and your duty of care is to the insurer. What is your duty? What do you have to take care about? You need to underwrite the risk competently, comply with the limit of authority, deal with claims competently, exercise care when you're delegating to people. That is really important. FCA are just very hot on that at the moment. As you know, they've just done a thematic review of that. And to maintain appropriate records and make them available to insurers. Now, I'm going to also look at this, which is when you can bind the insurer. And I'm going to look at that in a bit more detail and talk a little bit about what you've probably heard of, ostensible authority and actual authority. And that is quite an important area where you've got anyone who is acting as an agent. You need to understand the difference between actual authority and ostensible, or sometimes known as apparent authority. You're also going to have to remember about your fiduciary responsibilities, because you're obviously acting as an agent. And I mentioned the question of what a fiduciary has to do. If I'm a fiduciary and I make some secret profits, I must account for them to the person to whom I owe the fiduciary duty. Now, this was a case, R&V, with insurance. Risk insurance and reinsurance were their agents. And in this case, R&V were a German insurer, and an underwriter there got together with an agent at RIR, and they decided that they'd put an addendum on the back of a binder, and they were going to make a nice tidy extra commission and split it between them, and it all worked quite nicely for a while until some people started to do some digging, and R&V found out about it, and they immediately tried to cancel it, or did terminate it. RIR said, "What are you playing at? You can't do that." And R&V sued RIR for conspiracy to defraud them, amongst other things. And the court found that there was dishonesty, there was a conspiracy, you must account for the secret profits, and that the arrangement had to be terminated. But crucially, this secret profits thing comes up again and again. I don't mean to scare you by all that, but it does happen, and it's important to understand. Now, how do you deal with this? Well, we also need to look at the clearly defined parameters. But you might say, well, actually, look, as an MGA, I don't want necessarily for everything to be very clearly defined, and I like a bit of flexibility. You know, it makes life easier in some senses because you don't have to keep going back to the insurer. But it can cause problems, and that's what we're going to have a look at as well. But going back to actual and ostensible authority. So, what do we mean by actual authority? Actual authority is the authority you've actually been granted by insurers. And it's usually, you think, well, hang on, that's quite straightforward, isn't it? You know, we just, understand what, well, this case, Temple and actually, that's just say QBE, I'm sorry. That case went all the way to the Court of Appeal because they couldn't actually decide who had authority to conduct the insurer's run-off arrangements. So it's not obvious. But ostensible authority or apparent authority is basically, you have to ask yourself this: what does the reasonable person understand? What kind of authority does the reasonable person understand the agent had? And you have to look at what kind of impression you were given, your course of dealings, but it's very important because you'll see that ostensible authority can create issues, and we're going to see just how that happens. If a cover holder or an agent acts within the scope of actual authority granted to him under a binder, he has to exercise reasonable skill and care expected of him in the writing of risks and the assessment of the premium, for example. But where it falls below the standard of care, he's going to be exposed to a claim from a principal. But if he acts outside the actual authority but within his ostensible authority, he will bind the insurer. That is the key thing to remember. So the courts will look at whether they thought there was ostensible authority, and if they think that there was, then the insurer will be bound. But if he acts outside his actual and ostensible, then you won't bind the insurer. Okay. Is everyone clear on that? Nodding heads. It's very important. This is the real problem. This is the real problem area. You might be, but if someone says, well, I didn't know that they were acting outside their actual authority, because it seemed to me that he did have authority to bind that insurance. And if you can demonstrate that would have been the case for any reasonable person, then you're going to bind insurers. But if there was no way that anybody could have thought, looking at it, that you possibly could have had any kind of actual or ostensible authority, then you're not going to bind an insurer. So if it's way beyond the realms of what could possibly be reasonable. Okay? Now, let's look at some of the remedies. We know that the usual remedy that lawyers go for when they're instructed is for damages. But that might not always be appropriate. If an insurer were to sue an MGAA, for example, for acting outside the delegated authority, for binding them into a risk that they shouldn't have been bound under and that they've had to pay, and they're now trying to pass that back onto the MGAA for acting outside the limits of their authority. Quite a common arrangement, common position. Is damages going to compensate you adequately, or compensate the insurer adequately? You don't actually know necessarily what your loss is at that point. There might be ongoing claims into the future. You might not be able to assess what the amount of your loss is. So in that case, you may say, well, look, I want an indemnity, or I want you to put some reinsurance in place, maybe as well as some damages to compensate me for the losses to date. Avoidance is a common remedy, and also if they can demonstrate that they wouldn't have written this risk at all, in that case you're going to find they'll say, well, look, I want my premium back as well. Let's just look at one point as well. Causation. Now, causation is a legal phrase. If you want to sue someone because they have breached their duty, you have to also show that that breach has caused some kind of loss. Yeah? You can't just say, well, you've breached your binding authority and I want some money, or I want you to put an indemnity in place. You have to demonstrate that there's been a loss. Well, that might not always be the case, you see. So the mere fact that a risk has been negligently underwritten, say, by an MGA, will not automatically entitle the insurer to recover all the losses that have been suffered. What we quite often see is that an insurer will say, well, I would have written it on different terms, yeah? Or, I'd have put some endorsements in place, or I would have put a different premium. Has anyone seen that kind of an argument raised? Yeah? With some nodding heads there as well. Quite often they'll try to say, well, we wouldn't have done it at all. And then the other question that has to be considered, remoteness of damage. What do we mean by remoteness? If something is so unforeseeable, for example, if there was a major catastrophe in the world somewhere, and you'd bound insurers into indemnifying against that risk, And the insurer said, well, we never had that kind of exposure in mind whatsoever. And you'll just have to say, well, I'm sorry, we could not have foreseen that that was going to happen. So you won't be held liable in that kind of a situation. If the ultimate loss is just simply too remote. Yeah? And then finally, well, if a claim was brought against you, what kind of damages would you be expected to pay? And this is where we have the situation. The insurer, and this is the common way that the courts operate in this country. When you're talking about compensation, really the approach is we need to put someone back in the position they would have been had the breach not occurred. So in this kind of a situation, the insurer is entitled to recover damage to put him in the same position as if the underwriting had been carried out competently. And remember, you might get that combined with a request for an indemnity against future claims or a request for some kind of reinsurance that had to be put in place. Now, let's just talk about conflicts of interest. We've understood now how MGAs owe fiduciary duties to the insurer. What about also owing fiduciary duties to the insured? Now, in most of your cases, I'd be quite interested to hear about this. How many of your organisations do you also have arrangements whereby you there is broking going on as well in your organisation? Yeah? Anyone else? Okay. Now, so for some of you it's not a problem because your obligations are simply to the insurer, to the carrier, and that's fine. You don't really have to worry too much about the relationship with the insured. But where you've got a situation where your organisation is also dealing with clients, with the policyholder, then you must consider your potential conflict of interest there. And in those situations, it's very important to segregate the broking and underwriting functions. Is that?
Yeah, if the MGA has a direct contact with a client, but there's no broking on, it's just an MGA, do they have the same duty to, is that the same agency's duty?
So if you just your relationship's just with the insurer?
Insurer and the policyholder, no broker.
Right. Yes, you do have those dual relationships going on then. And I think it's important because it's important that in that kind of situation that you do segregate your broking and underwriting capacities. Well, I say... Yeah. I'm sorry. So I'm sorry. Direct sales. Yeah. I'm sorry. So you're not acting as a broker. You're not acting as a broker. Yeah. I'm sorry. I misunderstood. Yeah. So in that kind of situation, you don't have any. You're saying to the client that's approaching you, you're saying, you're coming to me. You want to buy insurance. I don't owe you any duties of care about the right kind of insurance, what's right for you. In that kind of situation, no, you're right. You don't have that. But it's where you're on the one hand, you're broking, and you do have relationships with and obligations, duty of care, etc. And on the other hand, you have got your arrangements with your insurers.
So in that situation that the chaps have just highlighted,
yes,
it would be cautious and good practice for them to actually have some kind of caveat on their documentation to say, we are not giving you any advice on this product.
Yeah.
Advice to go and take your own advice or something
yeah,
like that.
Something like that. I'm sure they do, and I think, but it's absolutely right. Where I hadn't thought about the direct selling point, and I'm glad you raised it because it is an interesting one. And you just simply say, look, don't owe the policyholder a duty of care, and you're coming to me. I'm selling the insurance. that you've asked for, and that's it.
But there would be a duty of care because you are selling the product, but not from an agent.
No, exactly.
There's a limited duty.
Limited duty. Yeah. Yeah. Yeah.
So, Julian, just so, in the MGA, we think that 10% of the business that comes into you as MGAs is retail business, and about 90% is wholesale. We've no real way of benchmarking that, which is what you guys are very kind to provide us with information. I'd also just add to that little gloss there, if you actually go into the thematic review about conduct risk, the FCA will not let you off the hook when you go to deal with high directly. You have to deal with them fairly. So there's going to be a little bit of an interesting discussion between the legal responsibility and the regulatory responsibility. And I think actually basically, even if you look at the legal responsibility, you're kind of a problem for the FCA if you employ the customers. So it's nothing that Julius is wrong, it's just what the FCA breathing down on that for the next few months. Yeah.
Well, and that's, I think that's right. So I think that is the situation on conflicts. They can be managed. You know, if you they do arise, but I think they can be managed as well. In terms of risk mitigation, again, I'd be interested to hear about what the advice from all the lawyers and the risk mitigators and the brokers on this subject is you've got to try and tie down and be absolutely clear about what you're authorised to accept, the class of the risk. Is it insurance? Is it insurance and reinsurance? What are you expecting me to do? What are the monetary limits, both for individual risks? Is there a collective limit for premiums? As I say, are reinsurance protections required? And geographical limitations. But how many, just again, how many in this room think that their documents are very precise, on how many like to keep them a bit looser? On the very, is there an argument to keep things looser, do you think? No. I think there's a lot of shaking head. I think there might have been in the past, because I think people like to have a bit more flexibility and not having to go back for instructions for authority each time. But I think now that the general view is that moving to what, that can just lead to too many problems. Wherever you've got discretion arising, you've got issues. So I think just try and keep things absolutely buttoned down, and hopefully that will, it's going to put you in a better position. So, professional indemnity insurance. Again, hands up those if you know, is your insurance under a bespoke MGA PI policy, or is it under an intermediary policy with a binding authority endorsement? Do you know? Yours is the second. Anyone? Yours is on a specific. Yeah, I think I spoke to Miller before this conference about the benefits of specific policies, and I think Gallagher's also have one. And the general suggestion from them is that actually you're going to find those kind of wordings much more specific. They are going to be it's going to be a better proposal form. I don't know if there is a view about that here. A more helpful, user-friendly proposal form. Do you know much about it? Were you on the bespoke one? Chap in the stripy tie, was that? Yeah. And do you see a benefit to that one, to that proposal form compared to a? Yeah, yeah.
So I work at Miller as well. I have a couple of different hats.
Excellent.
So in terms of the proposal form, it's definitely an advantage because the underwriter knows exactly what the information that's needed. So if it's a non-specific form,
Yeah.
then one additional information may need to be given, which is just deciding on what to provide and what not to. But yeah, it's much better to have a specific form.
Yes.
If it's just a broken form, then you're not necessarily providing information about the capacity that you're underwriting on behalf of.
Okay.
It just depends. From a wording point of view, there probably isn't a huge amount of difference between a broken wording and especially the civil liability anyway. There isn't a huge amount of difference, but there can be additional.
Okay. Is there a case to be made for keeping it on a traditional brokers or intermediaries policy with a wording with an endorsement?
It depends on the form.
Yeah.
I think it depends on your business model as well.
Okay. Right. Do you know why OIM is still on the?
We're on a Gallagher's Group policy.
Oh, on the Gallagher's Group. Okay.
Even though we've seen these,
All right. Okay. Well, so yeah, I suppose mixed views on that, but I think it's something certainly to look out for, and that's it. I think there's obviously, as it's been touched on, these arrangements between MGAs and insurers do need to be considered carefully. You need to consider the duties and obligations. And sorry, I don't know your name, but as you say, especially now with the advent of this thematic review that's come out, it's going to be the FCA are very hot on these delegated authority arrangements. Has anyone who's read the thematic review paper? Yeah, it's got a copy with me if you need it. But I mean, really, the conclusion seemed. I can tell you what the conclusion was for those that haven't read it yet. The review highlighted that some firms do not treat their delegated authority arrangements as outsourcing, and improvements are needed to due diligence and the way they manage outsource arrangements, particularly in considering and assessing customer outcomes. So yeah, you have a look at it, but we're definitely going to come under the spotlight from the FCA. Yeah, there's a question.
Earlier on in your presentation, you were talking about disclosure of secret profits. Could you relate that to MGA's holding profit commission contracts?
I think there's a distinction between where you've got. I think in that case that I referred you to, the R&B case, there was an arrangement there which was a dishonest arrangement, whereby there was an addendum that was put to the back of the binder, which actually only two people knew how it was meant to operate and why it was operating, and those were the two people that were benefiting from what was a dishonest arrangement. Now, so I think that's the way to distinguish it. Really, where you've got a dishonesty situation.
A simple example of that you actually doing is siphoning off money because you tell them to ensure that you collect something there. You've actually got a plus 5%.
Exactly.
And
That's not been honest, and yeah. So, yeah, no, exactly. It's not really worth it. So I was talking about what is being known and upfront. I mean, it's probably a common lesson here is that actually you do have to keep an eye out, keep aware of who has what authority. I'm currently involved in some high court litigation where the insurers thought that they were reinsured because they entered into a reinsurance agreement. It was brokered by an agent, who said that he had authority to bind the reinsurers. Now, lo and behold, all the claims have started to come through. A lot of claims have started to come through. And they've turned to the reinsurance, the insurers. And what have the reinsurance guys said? Sorry, we don't know what you're talking about. We've certainly never authorised any of our agents to enter into this arrangement, and we're not insuring you, and we're not reinsuring you. We're not. And there are documents there with the stamp of the agent on it, and there's a big question mark over those stamps, because now the reinsurer says, yes, we did give. This person was our agent for several things, for several pieces of business, but not, in no way did we authorise him to reinsure professional indemnity insurance on this book. So these kind of strange situations do arise, and you just have to keep your eye open for them. Make sure you are absolutely clear about what people's authority is, what their actual authority, what their apparent authority is, and try and really tie everything down when you're negotiating these arrangements. Has anyone got any questions? Richard, I think you had a query about your relationship with cover holders that are acting for you, and whether.
I just think this whole the whole MGAA thing is very confusing for a lot of people, because at one level you've got the people who are saying they're selling one product on behalf of an insurer. The next level you've got a broker who's dealing with retail clients who's got a binder.
Yeah.
I would call that a broker with a binder, but you can now call that an MGA.
Yeah.
And at the level that we're at, all we do is we give out delegated authority to our cover holders to bind business. Now that could be retail or that could be wholesale.
Yeah.
So you've got three different aspects there. When you're trying to apply this to those three aspects, it doesn't really fit.
No.
Because you've got different duties of care all the way along. And I think that's where it becomes a bit confusing when you're trying to say, if there's a breach, where does the breach occur?
Yeah.
At what level? And I think that's, we're finding a bit of confusion there. And then when does that escalate to an E&O for us, for instance?
Yeah. No, there are so many relationships going on between quite a few people. It is a bit of a minefield, and I think it's a developing area as well. There aren't actually that many cases that have gone to the courts yet. There aren't actually many reported cases involving MGAs. There are involving brokers, and there are a few involving cover holders, but and so you can translate some of the principles. But it's definitely a developing area.
Yeah, and I think which is right, because where we're involved in a sub-delegation, if there's been a breach by someone to be a sub-delegate and they're a wholesaler, but then there's also a retailer, is that an E&O for everyone in the chain, or is it ultimately the person who sits before the carrier who takes that responsibility?
Exactly.
I mean, ultimately it depends on the contractual documents, but it does change depending on what they all say.
Yes. And
that's what everyone has to think. That's definitely what we're finding. We have to be mindful of when we're putting these deals together.
No, I agree. Any other observations from anyone on this area?
Just go back to the slide about ostensible.
Yeah, sure.
So, could you give an example of that? If, say, we acted outside of our actual authority, how would you consider that we acted within our ostensible authority?
Yeah.
So would that be through allowing someone to write a class of business that maybe was on the main exclusion list, or over and above the sum insured that we're allowed to write to, even though the risk itself was acceptable?
That would be an example, and often it can be in the way that people you present people within your organisation present themselves to other people. It could be email chains, meetings, what they've said, what kind of authority they have led someone to believe they had, and if it's reasonable for someone to interpret that as them having authority, it's kind of that then the court will say that was ostensible authority, and it was, and you've bound that person. But I think it's really the cases, the ones where it's quite clear that it was outside your ostensible authority will be obvious to you. It's kind of like the elephant, you know. It will be quite clear. It's just in no way could you suggest that someone had that authority. It would probably be clear. But it's going to involve looking at all the documents, looking at the correspondence, communications, emails, telephones, meetings, and that kind of a situation. Okay. Yeah. Now that all comes down to whether the MGA has a broking obligations as an agent to the policyholder or the client. In most cases, if you as an MGA are using a broker to get to the client, then it's the broker's responsibility. And if the insurer, the carrier, has avoided the policy, then that's not going to be the call. That's going to be the broker's problem. If it's, for example, a non-disclosure issue, that's going to be the broker's problem and the client's problem.
But if you've got a situation where someone within the MGA has acted inappropriately, how is that the broker's problem? They might have a conversation with me about something which I purport to be capable of carrying. They're telling me the actual facts, they're not misrepresenting anything. So if my insurer turns around and says they want to avoid the policy, surely I'm still left holding some responsibility, irrespective of the brokers doing anything wrong.
No, I can.
So in that, I think we're all interested in that situation. However, the ostensible side of it, the ostensible situation is one that concerns us, because I think you were left holding the baby as an MGA. We wouldn't be able to just step back out of the middle.
What duty does the broker have to check that the MGA has authority when placing the
Yes,
that's the basic question. I mean, does he have a duty? I mean, he has a duty to check security of the insurer. Okay, that's just a standard duty. It's just an exclusive risk, and we'll do that with policing. What basic duty does the broker have to check that the agent is acting within his authority?
Well, I think that's right.
Yeah, but so, no, absolutely, but if the MGA's got themselves outside of the authority, then the brokers are going to really sense what we have. So, I agree, and I see the MGA. Yeah, that's what I agree. I think they put carrying seats and.
But I don't think there's one fits all answer to that.
No,
It's just a question of should the broker be asking the MGA is the primary question, isn't it?
And some of them do ask you to confirm that you have underwriting authority, don't they?
Yeah.
So it's the minutiae that ask you. It tends to be Lloyd's brokers that ask you, I think, rather than anyone else.
Yeah, I think the Lloyd's broker would have a security committee.
Yeah,
and so you would need to know that security.
Generally, they ask for a letter to put before the security committee. You're right.
Okay. Well, look, it's to be discussed, that discussion. So it's just gone quarter to. Thank you very much for your attention and involvement, interaction. It's been a good discussion, and look forward to seeing you during the course of the day. Okay.